As Jeff mentioned, my name is Alan Schwartzseid. I'm the managing attorney for the Orlando office of our firm, K. Bednar Rembaum. We've got offices in Pompano Beach, which is our primary office, also in Palm Beach Gardens and Tampa. So we really do practice statewide. Anyone that you're working with that needs an attorney or frankly just needs even day-to-day guidance real quick, that's what we do. We've been in business since the 90s. I have not been with the firm for that long, but the firm's been around since the 90s in one iteration or the other. We only represent community associations, very rarely owners. So the likelihood of any kind of conflict coming up is extremely rare. And frankly, we do that on purpose because our business is making sure that community associations have the knowledge and the representation that we think that they need and deserve. So in the same respect, my email is on this first slide. It's as@kbrlegal.com. If you ever have a question, if you ever need just quick guidance and you're not hearing from your attorney, which is something that I hear from a lot of people lately, if you're not able to reach the person that is charging you a bunch of money to do work that they're not doing, please feel welcome to email me, call me. Even if it's not a client that is working with our firm, even if it's not a client you never intend to work with our firm, I really would be happy to be a resource for you at the end of this class and going forward. So a little bit more about the firm very briefly. We've got 21 attorneys, so it's not one of those one-man shops. We have several different divisions within the firm, but anyone that is working with the Orlando office, I will be overseeing everything that goes on the day-to-day and the litigation and the collection, everything. So I just make sure that my clients and the firm's clients that sign with me are very well taken care of. Out of those 21 attorneys, 8 are board certified. I'm going for the exam this coming year, so hopefully that'll be 9. And we also have a construction certified attorney. So bottom line, anything that comes up in a community association that you might want to have to deal with, we're here for you, and feel free to reach out either via email, which I just gave you my email address, or you can give us a call at the number below the email address. So now that I've spent that time, we're going to move into the actual presentation. So why are associations allowed to actually do something here? And what do they actually have to do? This is really the most important thing that you can explain to your boards, or your attorney can explain to your boards of directors, as to how covenant enforcement is supposed to work in a community association in Florida. So here's the first point. The association is charged with the responsibility of uniformly enforcing the governing documents and all of your rules. If they don't, you're basically handing the owners an affirmative defense. So you've got to have the right to enforce in your declaration or some rules that are supported by the declaration. You can't just make up rules that aren't supported by anything and think that they're going to be enforceable. Unfortunately, it just doesn't work that way. So if the rules don't exist or they aren't clear, if it's not clear what those obligations might be, you're going to want to amend them so that they can be applied uniformly, consistently, and in a timely manner across the board. Those 3 things that I just mentioned are the most important things that an association can do to make sure that you're enforcing in a manner that's timely, uniform across the board for all owners, and consistent. In other words, you're doing the exact same thing every time, hopefully pursuant to a written policy that your attorney has prepared for you that says, if you violate the covenants, here's what will happen. And it's generally going to say, we're going to send 3 notices from management, or 2 notices from management. The attorney's going to send a letter. We're going to send an offer for pre-suit mediation, and we're either going to send, and that's a statutory letter that we'll get into later, and then we're going to send a self-help letter if the association has the right to do that. We'll talk about that later as well. Here's the important part. The directors owe a fiduciary duty to do what they reasonably believe to be in the best interest of the association, even if it hurts them, even if they don't want to do it, even if it's against their own personal self-interest. Okay, so the board has an actual legal obligation individually to vote in favor of pursuing enforcement when there's a violation. Every director needs to understand this. And they need to understand that when they don't vote to pursue enforcement when they should be, what they're doing is creating the opportunity for an owner to weasel out of the problem that they're causing. And that's literally the opposite of what you want to occur in a community association. Whether that's weaseling out by saying, well, I don't have to do this. And here's why, because you let this person do this and this person do this, or you've waited too long. Okay. The major defenses to an enforcement lawsuit. And, Jeff mentions I'm like an encyclopedia in some respects. I literally wrote the book on covenant enforcement that the Florida bar will be publishing in the near future. So I think it's more dictionary / encyclopedia, but I also wrote the book on defenses. So the major ones that we're going to talk about, and I'll just go through them now. Waiver. Basically, you had a right, you gave it up, and you can't enforce it now later. You told me that you wouldn't enforce this. Okay, that's a defense to a lawsuit seeking to enforce your covenants. You've got an estoppel defense. Think about an estoppel certificate. Okay, when you fill that out and you produce that and someone relies on it, you can't go back on your word. It's similar to waiver, but it's basically more about conduct than what you stated or what you didn't state. Okay, it's about you enforced against this person, but not this. You enforced against this violation, but not this, etc. It's your conduct that leads people to believe that you won't enforce going forward. Then you've got the time-based offenses, which are latches and the statute of limitations. Okay, latches is you snooze, you lose. You waited too long to enforce. It's too late to do it now. Statute of limitations on enforcement, which is basically a breach of contract, you're looking at a 5-year statute. So if you wait more than 5 years, it's pretty much you're out of luck. Okay, there are things you can do that we'll talk about later to kind of revitalize what you're trying to address. But you got to do it across the board. You can't do it with respect to one individual owner or one individual lot. So moving along, there are some specific covenants and restrictions that the board's going to be obligated to enforce. They're going to be architectural standards, rules and regulations, age restrictions, which are limited as to how they can be implemented and how they can be drafted. Be very careful with those. Run them by your attorney, because otherwise you can get in trouble when it comes to fair housing issues. Pet restrictions. Same thing with pet restrictions. You can get in trouble with fair housing with respect to people who have a disability and it's not a pet, it's an animal under the law. So, and if you are interested in that issue, we do have a class that's pre-recorded. You can go on our website, kbrlegal.com. Under the resources tab, we have every class we've done that isn't like this one. We won't be putting this one up because it's specifically for your management firm. If we do it for the general public, it goes up online 3 to 4 days after the class is over. And the ADA, FHA, fair housing and pets is one of the ones that you might check out. Restrictions on leasing and sales is another major issue that comes up. That's another class that we have online. Guest and occupancy restrictions are addressed in that same class. Parking and vehicle restrictions, keep in mind, if you are trying to enforce a parking restriction and your community doesn't maintain the streets or the roads and doesn't own them, you have no right to remove vehicles or enforce violations that are on that street unless they are separate and apart from just the fact that the vehicle's parked there. For example, you might be able to still enforce a violation if the vehicle that happens to be parked there is a construction vehicle or it's a commercial vehicle and you've got a commercial vehicle restriction. But if it's just, well, we don't allow parking on streets, but you don't maintain the streets, sorry, but you're out of luck. So that's one you're going to want to run by your attorney and either amend the declaration, amend the rules and regulations, or work with the county or the city so that you are maintaining those roads and you can enforce. Keep in mind that's an additional cost that your members probably won't want to spend. And then we've got nuisance conduct. Nuisance is basically you're annoying everyone with your behavior or a condition on your lot. It's one of the hardest things to prove. So what you'll want to do is make sure that your declaration is really specific as to what is a nuisance, not just loud noise. Well, okay, noise above what decibel level? And then you're going to want to measure it when you claim that someone is making loud noises. If it's odors, you're going to want to figure out a way to prove that. Get a bunch of testimony from 10 different people that have walked past this unit or this lot and can smell the rotting animal flesh. You'll excuse me, but that's the type of thing that we do deal with is someone who passed away in a unit. That is a nuisance, but only if your declaration and your governing documents are clear enough to say, here's what a nuisance is. Another thing that I recommend that a lot of communities don't do, and I don't know of any other attorneys that are doing except for me and our firm, is you make certain violations. We talked about fines for a brief second before we actually got started. make multiple violations of the same restriction that you're not going to file a lawsuit about every time it happens, or that you fine for and no one cares about the fines. Make that a nuisance under your rules and regulations. So that's something that I actually include in the policies that I draft for community associations if they want it, is if you violate the same restriction, let's say, for example, you leave your trash cans out 3 times in a matter of a year, that's a nuisance. And you can pursue that even though they've cured that violation. They've moved their trash cans back because it's something that has a significant likelihood of recurring. If you don't have that language somewhere in your governing documents, including in the policies or rules and regulations, you probably won't be able to enforce something like that, and you'll just be fining, and fining doesn't get curative action done. That's the problem I have with fines, among other problems. So moving along. Now, when you are actually going to enforce, here's what you need to do. The first step is tell the owner what they're doing wrong and how to fix it. Okay, it should say you're in violation of the restrictions, the covenants, the rules and regulations, whatever it is. If you are savvy enough, you can compile a list of violations and which provisions they violate and include that in the letter. Here's the provision of the governing documents, copied and pasted for your reference. This provision, Article 10, Section 12 of the Declaration, prohibits X. Okay, great. You've told them exactly what they're doing wrong. You've told them exactly why it's wrong. And now you're going to tell them how to correct the deficiency, how to fix it. Okay, that's your first letter, your second letter, your third letter. All of the letters management sends out should say, here's what you did wrong. Here's what you need to do to fix it. That's bare minimum. If you can attach photos, even better, because then people that claim, no, that's not true, I didn't do that, or that condition isn't on my property, here's the picture. Is that not your property? Exactly. So that's the response that we're looking for, is we want to, and you'll excuse me because I know that we're talking about people that live in a community, but we want to nail this owner and make sure it's clear you are in violation. There's zero question about it. You need to cure it. Because otherwise, these people will try and get out of it. They'll try and argue. That's not, I actually have someone arguing that grass that they installed is not grass, it's herbs, because they can't have regular landscaping. And that's why they pulled out all the plants that are in their community, because they have allergies. I mean, you'll hear tons of different things. You don't want to leave the door open for people to argue that they're not in violation when they blatantly are. So if you can provide that 3-step or 4-step analysis of here's what you're doing wrong, here's the provision of the governing documents, here's what you need to do to cure it, and here's a photo showing that it's happening, there's really not much that these people can say. When they don't comply, you move forward, you send the next letter, you send the final letter, and then you should have a policy, like I said, that says you automatically, not a board meeting occurs, you automatically send that over to the attorney to address. You should be sending all the 3 previous notices, confirmation that the violation is still in place, and an instruction to move forward. Easy, okay? You shouldn't expect someone to stop this prohibited activity unless you tell them to. If they don't know what they're doing wrong, they can't really fix it. So just be clear. And if they don't follow your guidelines, they don't follow your direction to cure the violations, it shouldn't be up to the board to decide whether or not that moves forward. If there is a violation, move it forward. If it's not clear that there's a violation, then you can have a discussion with counsel and with the board to determine whether it's something worth pursuing via that first letter in the first place. Jeff, you have something to add?
Just a quick thing. Thomas, thanks for joining us. I just sent you a link to go to panelist. So come on back in and you'll join the rest of your group as a panelist so you can freely ask questions as the presentation goes along. Thank you.
All right. Moving along. Authority to fine. So the association is allowed to fine. That doesn't mean it's a good idea. Okay. In HOA world, there's a statute that says you can do it. In condos, there's a statute as well. We'll go through HOAs first. Okay. Let me first start by talking about why I don't like fines. And I understand a lot of communities think it's a great idea. It's a moneymaker. Great. But there are better ways to recover the cost of enforcing your covenants. I literally had a discussion with a client yesterday about this, and we're in the process already of amending their governing documents. So a lot of people look at covenant enforcement costs as a cost of doing business. Most attorneys do. And they'll tell you, nope, this is a cost of doing business. Whether you recover it or not doesn't matter. It's whether or not you've got curative action, whether or not the owner cures the violation. Well, guess what? If you fine the owner, that doesn't cure the violation even if they pay. I couldn't care less whether they pay you the extra $100 to $1,000. That doesn't resolve the violation. It might give you the funds to do self-help, but if your declaration is drafted correctly, the owner's already going to be obligated to pay that cost. Now, the amendment that I'm talking about that I suggest all boards consider is you make it so that the cost of enforcing your covenants, if someone violates, that attorney's fee, that cost, all of it is due immediately once the matter's resolved, regardless of whether you file a lawsuit. That last piece is the one that's missing for most declarations. So most people see it as, well, we're going to send our letter, we're going to pay our attorney $100, $200, $300, and then the owner cures. Great. But where does that money go? It's gone. Correct. Unless you do it the right way. So again, amend so that it doesn't matter whether you file a lawsuit or not, you're entitled to recover your attorney's fees and costs incurred in enforcement. And I go a step further and say that that cost, once it's finalized, once that violation is cured, is actually an assessment against the lot. So what you're doing is purely holding the owners that made that happen and caused you to go after them and forced your hand to spend attorney's fees and costs by ignoring your first 3 letters and not curing the violation sooner. They are unilaterally responsible for the attorney's fees and costs that the association paid their attorney as an assessment, meaning you just tack it onto their account and you collect it just like any other assessment. I call it an individual assessment. A lot of declarations label it the same way. But the bottom line is you're basically saying, listen, yes, the association paid these amounts, but we're not just treating it as a cost of doing business and making all of the members responsible for something that only one unit, one lot actually caused us to spend money on. So this is something that I'm working on. I've got 3 of these in process right now where we're working on those amendments for clients of our Orlando office. Now, moving on to another reason I don't like fines, you're basically taking the judge's job. You're doing what a judge does. You're hearing evidence. Well, we'll get into the process in a minute. But the bottom line is I don't like fines because they don't get compliance. So the association can fine. The fine doesn't have to be provided in the governing documents in an HOA. The fine can't exceed $100 per violation, or for continuing violations up to $1,000 total, unless the governing documents say otherwise. That is your minimum. If your governing documents say it continues until the violation's cured, that's what you go with. A fine of $1,000 or more can become a lien against the parcel and collected through that lien foreclosure process if the declaration says you can do it. That's only in HOAs. Again, condos can't do this. You can't have a fine in a condo or an HOA unless you follow this procedure. And this is one of the other things I don't like about fining is, frankly, it's a pain in the ass, okay? You've got to have a board meeting. And this is a bunch of notes that I'm just going to condense into an explanation. Okay, you've got to have a board meeting. You then have to have the board approve the proposed fine. Okay, you're basically saying, yes, we vote to fine this person or this group of people for these activities. Next step, you have to actually provide 14 days notice. And the statute was clarified this year that it's not just you have to provide the opportunity for a hearing, you have to hold a hearing of a fining committee that is not comprised of anyone on the board, anyone on any of the officers, any managers, or any of their family members. So you have to find people, at least 3, that are willing to be one of the most hated people in the community. Good luck. I do see some people that are able to impanel this fining committee, but it's rare. Okay, if you're able to impanel the committee, you give that 14-day notice, the committee holds a hearing, they hear evidence of whether the fine should proceed or not. If they decide yes, the fine is passed, the fining committee will give the owners notice, and the fine is due within 5 days after that. If they say no, if the fining committee decides there will not be a fine, okay, there's no fine, done. Can't start over, you're done. There's no fine for this violation, at least as of right now. So if the fining committee says no, guess what the next step's going to be? The board, who gets to decide who's on the fining committee, is going to pull off the people that voted no. If the answer was yes and the fine is levied, you give your notice. Now, let me explain something that most attorneys don't seem to understand about this process. That fine has been accruing since the board decided that a fine would be levied, meaning that on day 14, you are not at $100 and it grows every day. You are at $1,000, or if your declaration says it's more, that you can continue for an ongoing violation, you're at $1,400. Your fine has been accruing the whole time since the board decided to levy the fine. The owner will never be notified of that and will never have to pay it if the fining committee says no. But just understand that fine continues to accrue even though the fining committee hasn't approved it yet. There is a case called Tahiti Beach versus Pfeffer that says fines are procedural, penal, and remedial in nature, and therefore supersede a declaration's provision to the contrary. So technically, there is an argument. I don't know that I'd want to be the one to make it without an amendment, but there is an argument that even if your declaration says you can't fine, this provision says you can, and the statute controls. I wouldn't recommend relying on that in and of itself, but it's an option, not a good one. For condos, the association does have the authority to fine. Basically, the only difference for condos is that you can't turn it into a lien. Suspension of use rights and voting rights. And as Jeff mentioned, by the way, if you guys have questions, feel free to come off mute and just ask. I usually will save those till the end, but it's a lot of words that I'm saying, so I can understand if you guys want to cut me off for a sec and ask a question or two. But if we don't have any of those, I'll just go ahead and continue. Not a problem.
Are you saying that you're wordy, Alan?
I've heard that once or twice.
And no, we're not related. I tend to be wordy too, but back to you, sir.
I try not to be. It doesn't always work. All right. Suspensions of use and voting rights by the board. So this is both condo and HOA. The board, and there is no separate fining committee for certain ones, and there is a separate committee for other suspensions. So make sure to listen for that. You can suspend the right of an owner, occupants, and tenants to use portions of the common areas and common elements, or any other association property. This is generally going to be your pool, your gym, clubhouse and rec room, and similar facilities, and voting rights if the owner is more than 90 days delinquent in any monetary obligation due to the association. The suspension needs to be approved by the board at a duly noticed board meeting. So if it's for 90-day delinquency, understand you don't have to have a separate fining committee meeting or a separate suspension committee meeting. This is just the board gets to make the decision. The suspension doesn't apply to parts of the community that are needed to provide access to the parcel, utility services, vehicular or pedestrian ingress to and egress from the parcel, meaning getting in and out, or the right to park. Now, keep in mind, one of the things that actually does work very well, that judges are now starting to understand over the last few years, is not blocking getting in and out of the community, is shutting off key fobs. That is blocking one method of getting in and out of the community. And judges, like I said, are finally starting to understand that it is not telling people you can't come in. Making someone actually show their ID is not restricting access. It's restricting a method of access, which is something I've been arguing since 2010. And it is not a basis for a judge to say, well, the association was wrong. In a condo context, you can't suspend use of limited common elements that are specific to the unit. So that's balconies, parking spots, things like that. In a condo, keep in mind also that monetary obligation needs to be $1,000 or more, and you need to provide at least 30 days notice versus just notice of a board meeting to suspend voting rights. That's a bigger interest. The voting rights are very important because that's how people decide what's going to happen in your community other than the things that the board gets to vote on. So the legislature and the Florida legislators basically said, okay, well, we don't want someone to owe interest of $50 and late fees of $50 and be precluded from voting at an election meeting because they owe $100. So you have to actually provide notice in a condo, and you have to have at least $1,000 or greater debt before that board meeting occurs in order for that 90-day delinquency to be good enough. You need to provide notice of the suspension after it's approved. There is the De Soleil case that says the authority to suspend voting rights needs to be in the declaration, or there needs to be specific language in the declaration adopting later statutes in order for this to apply. I don't think that applies to use rights, but just understand in a voting context, this is a stronger interest. So you're going to want, before you suspend any voting rights, just run it as a general proposition by your counsel to see if that language exists, so that the board can make an informed decision of whether they're taking a risk or not in suspending someone's voting rights. If those voting rights are suspended, the vote doesn't count for any member vote in the entire community, whether that's amendments, whether that's an election meeting, it doesn't matter what it is, the vote doesn't count. It also doesn't count towards a quorum. So that may be a good or bad thing, depending what you're trying to accomplish at your election meeting or your member meeting, whatever that meeting may be. There are also rights to suspend those same rights. Sorry, I just repeated myself. You can suspend use rights and voting rights by use of a covenant enforcement committee. You basically do the same thing as you would for fining, but this is for violations of the covenants, and you can actually have it during the same meeting, where you're basically saying, we're going to fine this person and suspend their use rights because they're in violation of the covenants. They get the same 14-day notice. The committee gets to decide whether the suspension goes in place or not, and that's it. So again, the difference is if you're suspending rights with respect to a delinquency, only a board meeting. If you're suspending rights for a violation, it's the same concept, but you do need to have that committee meeting in addition to the board meeting. And then same thing, you provide notice just like you would for the other suspensions after that committee approves the suspension. In an HOA, I'm not going to walk through everything that's subject to pre-suit mediation. The important one here is the one at the bottom, covenant enforcement. I do want to include this so that you understand when we talk about pre-suit mediation, all of these things are going to be subject to that process when I go through what that process looks like. There are certain disputes that are not subject to pre-suit mediation. So I've had this happen maybe 4 or 5 times. I was in the collection process against an owner. They argued that we didn't comply with pre-suit requirements because we hadn't offered mediation. Okay, great, but that's not required, and it's expressly written into the statutes that the association doesn't have to go to pre-suit mediation for collection. So again, just a list of items for your benefit. I'm not going to go through them in detail. Condo dispute resolution is a little different. You can either go to pre-suit mediation, which I guess now's a good time of explaining what that actually means, or you've got other options. So I'll go through those 3 options and explain what they mean, what the process entails real quick. Pre-suit mediation is usually your last step before you file a lawsuit, hence the term pre-suit. It's basically a process where the parties get together, usually with their attorneys, if the association has an insurance attorney because they're the ones being threatened, that's fine too. There might be a couple attorneys. If the other side has an attorney, great. If they don't, okay. But the parties get together with counsel and they sit in a room. Now it's mostly done via Zoom. And there's a mediator that is involved in this meeting. Okay, the purpose of the mediator is not to say who's right and wrong. Matter of fact, that mediator needs to be completely unbiased throughout the entire process. So I actually serve as a mediator as well. And my job as a mediator is to tell the association's attorney, here's what the strengths of the other side's case are going to be. Here's the weaknesses of the other side's case. But I need to do it in a way where I'm asking questions, and the attorney's going to tell the association what those strengths and weaknesses are. So the mediator's goal is, frankly, to push the parties towards settling. Okay, because that's the whole goal of mediation. It's a confidential process. So anything that's discussed in mediation that doesn't go into a written settlement agreement is not something you can bring up in court. So this is also the opportunity for the parties to meet semi face-to-face or actually face-to-face and tell each other why they think they're right and the other party's wrong. It's also the only opportunity you'll get to admit that you have weaknesses in your case and that you're wrong without the other side being allowed to use that against you in court. Okay, so that's mediation. It's completely voluntary, at least as to the final decision being made. The board gets to decide what's acceptable and what's not. The other party gets to decide what's acceptable and what's not. No one's telling you what the settlement terms are. They may be pushing you towards settlement terms, but you're deciding, or frankly, because you guys are all CAMs, your board is deciding what that looks like. Now, what I recommend is before that mediation conference, set a meeting with the attorney to decide what's going to be acceptable, decide who's going to attend the mediation, because you don't have to have the whole board there. You can have one person delegated the authority to settle on behalf of the association. Usually that'll be the president, but it doesn't have to be. So if during that board meeting, that'll be a closed legal meeting of the board, by the way, you decide, okay, we're willing to accept the owner curing the violation and paying the fees and costs that they've incurred. Great. Those are your settlement terms. If it's the owner needs to cure the violation in 6 months and pay the fees and costs in a year and a half, also great. That settlement is almost always going to be better for the association, even if it means that you're giving the owner more time than spending the next year in litigation and spending more money continuing to fight this. Now, I know that sounds probably a little bit less aggressive than you'd like to see. The bottom line is, I want the association to have the resources to fight the tough battles, not waste your time fighting with someone that you don't need to be fighting with. So we, and when I say we, I mean our firm and I are as aggressive as you want us to be. It's just a matter of logic. Every move you make in the enforcement, collection, any process you're taking as an attorney should be geared towards getting that matter resolved and getting the result that your client wants, which when it comes to covenant enforcement is having someone cure the violation or getting your judgment. I prefer to have every move be in the direction of both of those. Okay. You want to get your resolution. That's all that matters. The attorney shouldn't be playing games with the other side. They shouldn't be, spending hours sending angry emails back and forth. They should be trying to get you your result, which is curative action. All right. So off my soapbox real quick. In a condo, the only alternative used to be non-binding arbitration with the DBPR, which is a state entity that hires arbitrators who have expressly stated that they're allowed to make decisions in an arbitrary manner. In other words, precedent doesn't matter to these people. Why would you want to take your case in front of someone that gets to decide your fate and doesn't care about legal precedent? What that means is there's no way to predict how this is going to play out. So you're praying that that arbitrator decides to actually follow precedent and follow Florida law. If they do, great. You can then enforce your judgment in court. Those arbitrators will also almost always reduce your attorney's fees significantly. Okay, I've been told by an arbitrator I'm worth $225 an hour. I charge less than I was charging before now, but I was charging $375 an hour at my last firm. Okay, now it's $325. But to be told that my hourly rate of $375, which my clients happily paid, was to be reduced to $225 when the association won, means that the association was out $2,000 to $3,000 in attorney's fees that they shouldn't have to be out. So bottom line, rather than belabor the point, you can now choose in a condo or a co-op between binding arbitration, meaning that there is no go back to court. The arbitrator decides that's a really bad idea. Non-binding arbitration, which is the process I just described, also not a great idea, but somewhat less risky because you're still going back to court. And the one that we prefer, and I think is the most beneficial, is mediation, because you're trying to get it settled. If you don't get it settled, you go straight to court. So when you don't settle at mediation, or if the owner doesn't respond to that offer for pre-suit mediation, there's what's called an impasse, which means you go to court. You file your lawsuit for an injunction. Now, before you file your lawsuit, keep in mind, I don't think we have it in the slides, but let me move on a little bit and we'll see if we have it. But self-help is a major issue in recent years. And again, disputes that are not subject to pre-suit mediation, I won't go through. Additional ones. Okay, so we talk about the offer for pre-suit mediation. I'll talk about the self-help letter after we go through what needs to be in this offer. It's basically a letter. It's statutory form letter, but you fill in the blanks of, here's the violation, here's the name of the declaration, here's the community, here are the parties, some other information, etc. It's sent by certified mail, return receipt requested, with a copy by regular mail to the owner. It lists 5 acceptable mediators, which we select, people that we trust to know this area of law, and it provides 20 days to respond by certified mail, agreeing to mediate with one of those 5. So if the owner agrees to mediate and says, I'll agree to mediate with John Smith, and John Smith wasn't on our list, our response is, okay, we'll mediate, but just understand that this is not a compliant response. The reason that matters is because if the owner doesn't send a statutorily compliant response, meaning they respond by certified mail, return receipt requested within 20 days, agreeing to one of our mediators, they have waived the right to recover attorney's fees and costs in the lawsuit, even if they win. So I will generally say mediation is a beneficial process. We'll agree to mediate, but just understand we're not waiving the deficiency in your response. In other words, we're not waiving the fact that you're not entitled to attorney's fees and costs. And by the way, guess what? The first thing I'll bring up in the middle of that mediation is when we walk in. I just want to clarify as part of our opening statement, we're here today trying to settle. However, we want it to be clear that we're in a strong negotiating position, because even if the owner decides that they don't want to settle today and we file a lawsuit and they win somehow, they won't get their fees and costs back. So they're spending a bunch of money for no reason. If the parties agree to mediation, the mediation happens within the next 90 days. The parties split the mediator's fee equally. I usually try to make them paying the full mediator fee part of any settlement if possible, so that the association's not out that money. If an impasse is declared, meaning that you had the mediation but you didn't settle, you get to go ahead and file your lawsuit. And if they don't respond within the 20 days, you also get to file your lawsuit. All right, moving on, arbitration. It's basically a mini lawsuit, and frankly, I don't like it. You might end up stuck in it anyway. If you do, feel free to read these slides or to reach out to me or your counsel as to how that process will go. But the bottom line is, I don't think any community association in Florida should be electing to go to arbitration in an enforcement dispute. Let's see. Okay, so we don't address self-help in the slides. I'm going to address it now. Self-help is the process where you basically are going onto someone's property and curing a violation for them and charging the cost to them. Okay, it's something that a lot of declarations include. Some do, some don't. But there's recent case law that basically says if you've got even the right, even if it's not you have to go onto the property and cure it, if you have the ability to go onto the property and cure that violation, you have to do it, and you can't get an injunction. The reason for that is that one of the essential elements, that's a legal term that means the requirements to get an injunction, is that you have no adequate remedy at law. The courts consider the ability to go onto someone's property and cure a violation an adequate remedy at law. And the recent decision about 2 months ago in a case called Meconico was that even if you're going on and you're worried that going onto someone's roof, for example, and fixing their roof and having someone pull down the ladder, scream at your vendor, or worse, you jump on someone's roof, they might pull out a gun and shoot you in the face. That risk is too speculative to justify not going out and attempting the self-help if you've got the right in your declaration. Okay? That's case law now. That's Florida courts telling us if you have that right, you have no choice. You have to try it. If you try it and the owner interferes, then you can go get your injunction. My suggestion to every community association in Florida that has this right, that isn't willing to take the risk of going onto someone's roof, power washing their house, spraying for weeds and risking someone claiming they have asthma, digging in to shield a water treatment center on the side of the garage from public view and risking that you're going to tear a utility or an electric line. Doing all that stuff is risky. There's no question. But that risk is too speculative to justify not attempting it. So my recommendation for every community association in Florida that has this is amend the governing documents so that the only right the association has for self-help is the things that they're willing to do. Usually that's going to be basic lawn maintenance and landscaping. You're going to mow the grass, you're going to edge, you're going to remove weeds. That's it. You're not going to do anything else. So that's another one where there are 5 amendments that I'm working on right now for communities that we work with to try and remove most of that self-help right so that the association does have the ability to go straight to that injunction lawsuit if the settlement doesn't take place. Now, with respect to self-help, if you are going to demand it, my suggestion is when you send out that offer for pre-suit mediation, send that self-help letter at the same time, so that you also have hanging over the owner's head at mediation that if you don't settle today, fine, the association is just going to go on the property and fix the problem and charge them the cost. So that's the timing of when I'd send it out. Now, I do have some communities that don't even want to go to counsel if it's a self-help issue. I'm fully in favor of that. You're spending less money. Have me prepare a form for your self-help. You send it out. You let the owner know within 15 days we'll be on your property to cure it. You cure the violation. It never reaches me. The way to do that, though, is to make sure you've got a policy in place that lets all the owners know that that's how you intend to do it. Because if you've been sending 3 letters before it goes to an attorney and you've never done self-help before, but now based on this new case law, you're suddenly going to decide to do it, that's concerning. That's a problem. So you want to make sure that you're giving the owners notice, hey, not only is this our new policy and what we're going to do uniformly, consistently, and in a timely manner across the board going forward, but we're also going to give you notice that, hey, you in particular, not just the community, but your violation is one that we're going to treat within the next 15, 20 days, whatever your declaration provides for. Okay. The other thing that's not in the slides that I do want to address, and it is in the slides. It's in this one, actually. So I'll wait to get to it. Fair Housing and Americans with Disabilities Act is one that I mentioned. You might want to watch our PETS class. But these are limitations on what you can and can't enforce. So you might have age restrictions, you might have religion restrictions, use of the property for religious purposes, blah, blah, blah. All of this, the age, sex, all these types of discrimination claims are all going to fall under fair housing and ADA. The bottom line is you can't discriminate. You have to make sure that everyone has the same use of the property if they ask for an accommodation. And if they don't ask for it, just understand you may still be required to provide it at some point. Okay, they do have to ask, but you're limited in the questions that you can ask these people that are saying, I want to have a pet, but it's not a pet, it's a service animal. It's an emotional support animal. Okay, that's another policy that I suggest every community has. Not so that you dictate how they're supposed to make the request, but so that the association knows the process to go through kind of step by step so that you avoid violating those laws. OTARD is an over-the-air device rule, and it's basically that you have to allow people to have satellite dishes on their property. You can control where that satellite dish or that antenna is located, but you can't tell someone that they can't have it on their property. So a lot of times people will install it and then request architectural approval. You should have in your architectural guidelines, if you have any, the location of where that should be. The thing that you need to keep in mind for OTARD is that you can't restrict it to only being allowed in places where it won't function properly. Again, satellite dishes, antennas. So if that satellite dish won't be as effective because you required that they put it in the southeast corner and that southeast corner doesn't get a signal, sorry, but you're going to be in violation of this federal law. Solar collectors is the same thing. You have to allow people to have them. You can require them to go through the application process, but you can only restrict it as to location. You have to allow people to have them on their roofs. And that actually extends even to condos where they have to dig into the roof in order to install the solar collectors. Now, one thing that I have done is require that owners sign an agreement that basically makes them responsible for the full cost of repairing the roof, any insurance costs that are increased as a result of their installation, etc. But you have to allow it. It doesn't mean that you have to allow it in the easiest fashion. Flags, there are restrictions on what you can say people can and can't have. Technically, at this point, people are allowed to have 4 flags if they're allowed to put the they can have 2 if you're in an HOA. They can have 2 flags on their house itself, on the residence, and 2 on a flagpole. There are limitations as to the size and location of the flagpole and the flags, and there are locations as to what type of flags you have to allow. So those are things, if you're not sure, it's basically the US, the state flag, and the military flags, and certain first responder flags you have to allow in general. and on certain days of the year. Florida-friendly landscaping is something no one understands or cares about until an owner comes back and says, I'm installing these stones and this xeriscape on my property because it's Florida-friendly and you have to allow it. The answer is yes, unfortunately, you do. No, unfortunately, most attorneys will not be able to tell you what is supposed to be allowed and what's not. It's basically stone instead of grass and other landscaping. The problem with that is that if you give up that landscaping, you give up the grass, and you put down pavers or you put down stones, your drainage is impacted. So unfortunately, there's not much you can do about that, but just understand you should be letting your owners know that if they install this stuff, it'll be allowed, but if drainage becomes a problem, they'll be responsible for fixing it. Now we get to the final pain in the behind. There's a new statute that came into place and took effect in July, 720.3045. This is HOA only. Anything that can't be seen from the frontage of the lot or an adjacent lot that is installed on the property is not something the association can restrict. So what that means, the frontage is basically, here's the residence. I can't do depth on Zoom, sorry. You've got your two sides of the lot. You've got the front of the lot, you've got the residence. If you can see from here to here, then it's something you can restrict. If you can see from an adjacent lot, it's something you can restrict. If you can't see the thing that was installed from either of those locations, you can no longer restrict it. So people that are parking low boats, putting pavers in the backyard, if you can't see it from the frontage or an adjacent lot, you can't enforce it. Now, keep in mind, this is not conditions on the lot. So again, if those pavers start causing drainage issues to a neighbor or to common areas, that's a violation that you can enforce regardless of whether you can see the pavers. Okay, if it's a condition, they're installing a chicken coop. Okay, they're not allowed to have chickens. Well, if you can't see it, okay, maybe it's not enforceable. I promise you will hear those chickens. I can tell you because my jerk of a neighbor decided to install a whole bunch of fencing and has chickens roaming in his backyard. So I promise you, you'll hear it. That's a separate violation. It's only things being installed. Now, the other question that I have that hasn't been answered by a judge yet, because it's too soon after July for really any decision to be made. If I can peek around the fence, if I can peek over the fence, technically, from my perspective, that's visible from an adjacent lot. So it might still be enforceable. Now, the one caveat that I will mention, which is an absurd limitation of this law, is an adjacent lot probably doesn't include a lot that's located across a lake or across a grassy area. So if you've got a backyard that abuts to a lake, the neighbor across that lake who's still in your same community and has a backyard that abuts to the lake and can see all of the crap that you've installed in your backyard, that's not an adjacent lot, and that doesn't make it enforceable. So this is just a bunch of crap that the Florida legislature thinks, or the federal government thinks, is more important than the contractual rights of your association that all of these people chose to live in or chose to own a property in. I don't think that it's right, but it's the law, and there's not a whole lot I can do about it other than, as Jeff mentioned earlier, try and get the Florida legislature to understand a little bit better how community associations operate, because most of these people have no idea. So that's all I've got. Again, my email is right here. I'm going to go ahead and shut down the webinar portion, but we're still sticking around for Q&A. If you've got anything at all, feel welcome to just ask now.
Hey, everybody. Feel free to chime in and ask questions. In the meantime, I am going to pull up the evaluation screen and put a link into the chat, and I'll briefly go over that with everybody. But Alan will take your questions in the meantime as I pull up the evaluation page. So anybody, feel free to come on in, ask a question, suggest something you want to see in the future, anything. We'll take it all.
I don't have any questions. I just wanted to thank you guys for joining us today. We really appreciate it.
Sure. Happy to help.
Thank you very much.
You're
Hey,
welcome.
Alan, I do have a question. So the community that I manage is been established for 15 years. outside of it's hard to get the governing documents changed to, what you were suggesting before about saying, hey, this is now a nuisance because you've been a repeat offender of the same thing. So what I'm seeing, because we just reestablished our fining committee back in May, is that some people are habitual offenders with parking on the street, which isn't allowed because we do maintain the streets here. Trash cans out and like basketball hoops, which aren't allowed to be left out. So what's the appropriate way to address fining them? I've had a couple addresses go to the fining committee. It went before the board of directors, went to the fining committee. They approved fining for the infraction, but obviously something like trash cans, basketball hoops is easy to rectify. But if they were to violate again after the fact, what's the process for fining in that situation?
Well, it would be a new violation, so technically you would just start that fining process over. I think I've been clear. I don't like fines, but if it's working for this particular community, have at it. I'm not going to tell a community you can't fine. I just don't think it gets you what you want. And then with respect to, so that's the answer, is you just start over every time that they violate this process. If they cure the violation, part of the reason that I include, so it's not an amendment that's required in order to implement hey, if you do this more than 3 times, it's a nuisance. It's just part of your covenant enforcement policy, or it's a new rule or regulation. So that's something that the board gets to decide on. It doesn't matter what the members want. The board gets to decide that this is now the way that we're going to enforce. And then, a judge gets to say, well, I think that, the fact that they only violated this 4 times in a year and were found in violation is not enough. I've never seen a judge say that that's an unreasonable rule to put in place, that, listen, we're not going to go onto your property and take your car and tow it. We're not going to go onto your property and take this basketball hoop and throw it in the dumpster. We're going to go ahead and fine you. But if you continue ignoring the fines and ignoring the fact that you are continuing to violate this, we got to have some kind of enforcement mechanism, and this is it.
Got you. So it's more of a board resolution than changing of the documents. Okay.
Right. It's not an actual amendment to the governing documents. It's just either a new rule and regulation, or it's part of your covenant enforcement policy that just says, if you violate the same restriction X amount of times in any, it could be 6-month period, it could be a year, whatever you want it to be. It could be 3 months for all I care. Chances are you're not going to have 3 different violations in 3 months, but for trash cans and things like that, you might. So right. Whatever the time frame is that the board wants to use, that's what goes into that policy.
And as far as fining for like trash cans, that type of thing, so if they were to go in front of the fining committee says, hey, we'll fine if it's not rectified. At that point, if they were to do it again, say it's November 7th and they do it again and it's already been reviewed, at that point it's saying, hey, I can have the board review it for an immediate fine for that day, like saying, hey, $25 because you left it out that day. And then the fining committee could review that and also say, hey, we approve that $25 fine for November 7th. Yeah,
I mean, the problem is if the fine was levied and it's not ongoing, meaning they actually took their trash cans in, basically have to start the whole process over. So the board has to have that fining committee or that board meeting. Then you give the same 14-day notice you gave before. This is why I think it's absurd to continue going through that process and, basically waiting until the owner clearly will have put the trash cans away, or presumably the trash was collected again before the fining committee can even meet. That's why I say it makes more sense, in my opinion, to have something in place that says, listen, if you're going to be a habitual violator, we need to have a mechanism that isn't just, we're going to start this process over and you can easily resolve the violation before the fining committee meets.
Right. Okay. Thank you.
You're welcome.
Hey, I had one question about the new HOA line of sight changes that came up. If you manage a property that borders not association property, like a golf course, or by something like a storage facility that you can see homeowner lots, the backsides of, is that addressed yet? Because they're not association. Okay.
Yeah, I mean, it's addressed in the statute by the fact that that's not association property. So that would not be enforceable because it's not an adjacent lot within the community, and it's not the frontage of the property.
Awesome.
So, yeah, exactly. That's why I think this is a terrible law, and it's one of those that I'm hoping my partner, Mike Bender, is up in Tallahassee working on getting either clarified or removed from the legislature. You guys got to understand, and a lot of people don't, that most of the laws that come out that we look at and say, what the hell is this, is purely reactionary by one legislator that got screwed over or their family member did. So that notice of late assessment is because one legislator's mom got a demand letter to pay attorney's fees of like $800 in a notice of intent to lien. That's how this stuff comes about. So I guarantee you this 720.3085 was the result of someone saying I should be able to do whatever I want in my backyard, and ignoring the fact that the associations had, in some of these cases, and I'm not saying your communities in particular, but some of these communities have had these regulations in place since the 70s. And the legislature is just saying, well, you know what? It doesn't matter anymore.
Yeah, but
Well, thank you.
Just because something was in the 70s doesn't mean we're old. I mean, doesn't mean the law's old.
I'm not saying that it's old. I'm saying it's been.
I'm just kidding.